my name is Dr. Alexandra Franks, and I am a lecturer here at Auckland Law School. So by way of a little bit of background about me, I'm an Aucklander. I grew up in Auckland. I practiced law in Auckland for a while, and then I went overseas. I did some postgraduate study, so I did a Masters of Law and a PhD at the University of Cambridge, and I also practiced law in London for a bit. So that's me, but then I came back here to Auckland to take up a position as a lecturer. I teach on one of our first year courses, so if you're interested in the law program, you might have found out that there are 3 required first year courses. There's Law 121, there's Law 131 and Law 141. So I teach on Law 141, which is Legal Foundations. So in that class, Legal Foundations, I talk to our students about sort of introductory criminal law kind of ideas and introductory human rights kind of ideas. So if you do come to study law, you'll be taking 141. It's one of the required papers, and so you might see me again there. For the later years in the law degree, I teach the law of evidence, and I also teach trademark law. So that's me, and what I'm talking to you about today, apart from how great it is to study law, obviously, is this issue of whether a photo taken in public can be used in court. And to talk to you about that, I'm going to tell you about a case that has been going through our courts recently. So the case is called Tamiafuna and the Crown. And the facts of this case are that Mr. Tamiafuna had a photo taken of him by a police officer. So the way that happened is Mr. Tamiafuna was a passenger in a car. The car's just driving along. Police officer pulls the car over, checks the license of the driver, and finds that the driver does not have a license. And so the police officer impounds the car and says to the people in the car, including Mr. Tamiafuna, you need to get out of the car because we're impounding it. You need to find another way to get home. So everybody gets out of the car. There's no suspicion that Mr. Tamiafuna has done anything wrong or anything like that. And while the people are standing on the side of the road waiting for their alternative transport, the police officer takes some photos of the people who are standing there. Now, the photo of Mr. Tamiafuna is then uploaded to the police database. And through that process, it's then found that the photo matches some CCTV footage that was taken 3 days earlier after an aggravated robbery. So it's then through that photo that the police are able to identify Mr. Tamiafuna as having been at the aggravated robbery. So they didn't know who the person was at the aggravated robbery before. They had some CCTV footage, but it wasn't clear enough to sort of see the face, but there was distinctive clothing, and it was the same clothing that Mr. Tamiafuna was wearing in the photo. So what that means is the police are able to charge Mr. Tamiafuna with having been at the aggravated robbery because they've used the photo and they've identified Mr. Tamiafuna as having been that person. So Mr. Tamiafuna gets convicted of aggravated robbery. Now the only evidence that's linking him to the robbery, or the key evidence that's linking him to the robbery, is the photo. And Mr. Tamiafuna argues, unsuccessfully, that that photo was taken unlawfully and in breach of his rights under the New Zealand Bill of Rights Act. So in the New Zealand Bill of Rights Act, we all have a right to be free from what's called unreasonable search and seizure. So Mr. Tamiafuna tries to argue this photo was taken unlawfully because the police had no authority to take the photo. They're not investigating a crime, which would be different, then they might have authority to take the photo. They're just taking the photo on the side of the street for no real reason. And as a result, he's trying to say that that photo, come on in, just hopefully, maybe on this side you'll find a bit more space. He tries to say that that photo was improperly obtained evidence and therefore should be excluded, which would mean that there would be no evidence to link him to the crime, and therefore he would have to be acquitted of the aggravated robbery. So that's the argument. Those are the issues. And as I said, this has been going all the way through to the Supreme Court. So we're waiting now to hear from the Supreme Court what they're going to say about this case. And this case raises a number of kinds of law that you might come to law school and you might learn about. So it raises criminal law issues. So what are the requirements for Mr. Tamiafuna to have been convicted of aggravated robbery? What does he need to have done in order to have found to have committed that aggravated robbery? It raises issues of criminal procedure law in terms of what the police are allowed to do when they're investigating crimes. It very much raises issues to do with the law of evidence, as the question being, is that key piece of evidence, the photo that links him to the crime, is that something that the court is allowed to hear about? And it also raises issues to do with human rights law. So was there a violation of Mr. Tamiafuna's rights through the taking of the photo and uploading of the photo to the database? And there are also pieces of legislation that govern these areas of law. So we have the Search and Surveillance Act 2012, which has rules for what the police are allowed to do when they're trying to surveil people, which don't really apply in this case because it's just coincidence that they take a photo of Mr. Tamiafuna. They're not sort of following him because they think he's committed a crime or anything like that. There's also the New Zealand Bill of Rights Act, the right to be free from unreasonable search and seizure. There's the Privacy Act 2020, which has some principles in there about the taking and retaining of our personal information, which a photograph can be said to be our personal information. There's also the Evidence Act 2006, which has a provision which talks about what courts should do about improperly obtained evidence. And then the Crimes Act 1961, which tells us the elements of the offence of aggravated robbery. So the issues in the case, what the courts have been arguing about. So first, the first level court said this evidence is not obtained in violation of the law or anything like that, and it should be admitted, and that's fine. And then there was appeal to the Court of Appeal. The Court of Appeal said what the police did was unlawful, so there was a violation of Mr. Tamiafuna's rights, but they say we will let the evidence be admitted anyway. And now it's before the Supreme Court to decide what the outcome should be, the Supreme Court being our highest court in New Zealand. So the issues, if we were a class of law students and we were in my evidence law class, for example, we would be talking about what does it mean for evidence to be improperly obtained. And there's a particular definition of improperly obtained evidence in Section 30 of the Evidence Act. And so we would be talking about the circumstances of the case and seeing, do the circumstances meet the test for improperly obtained evidence? And if we decided that the evidence had been improperly obtained, which we would say yes if we say it's been obtained in breach of the New Zealand Bill of Rights Act, which would require us to decide, has there been an unreasonable search and seizure of evidence in relation to Mr. Tamiafuna, or has the evidence been unfairly obtained? If we said yes, then we would have to go on and consider, should the evidence have been excluded from the trial? And then there's material in the Evidence Act which tells us the way that the judges are meant to make that decision in deciding whether to exclude the evidence or not. So that requires us to understand an important part of court process in New Zealand and many other countries around the world, which is that a jury, if they're deciding something about a case, they can only decide based on the evidence that has been put before them in court. So it's only the material that the lawyers have properly put before the jury that the jury is allowed to take into account in reaching their determination of, has this person done the thing that they're accused of doing? And that's the same in a civil case as well, where we have a judge deciding the outcome. So in a civil case, the judge can only decide, for example, that there's been a breach of contract or some problem in an employment dispute, so on, based on the evidence that the lawyers have put before the court. So what that means is there might be a whole lot of material out there in the world that might relate to the case, but if that hasn't been put before the court, formally put before the court, then the fact finder, which might be the judge in a civil case or the jury in a criminal case, is not allowed to know about that, and if they do know about it, they're not supposed to take it into account in reaching their decision. So we have evidence which is called inadmissible evidence. So that means there are rules that say for various reasons, this type of evidence is evidence that is not allowed to be put before the court. We also have evidence potentially that's excluded evidence. So a judge has made a decision to say, I'm deciding that you're not allowed to hear about that evidence. And then because we're relying on the lawyers to put the evidence before the court, there might be evidence that's out there that for whatever reason they haven't put before the court. They might not know about it, they might have made a tactical decision that they don't want to put that evidence before the court, and so on. So here, in Mr. Tamiafuna's case, if it's correct that the evidence should have been excluded, then that means that had he had a trial, the jury would have never found out about the photo that links him to the aggravated robbery. And therefore, there would not be enough information for the jury to say, yes, beyond reasonable doubt, Mr. Tamiafuna has committed this crime of aggravated robbery. So Mr. Tamiafuna would have to be let go, despite the fact that out in the world, it is true that he was involved in the aggravated robbery. So it is true that he was there at the aggravated robbery. Everybody admits that that is the case. But if that evidence is excluded, then he has to be acquitted. So now I'm going to ask you what you think in this case. So if I'm telling you that first we have to decide if the evidence is improperly obtained, and the evidence will be improperly obtained if it was found in breach of the New Zealand Bill of Rights Act, and then there's another step in the chain there where it will be found to have been in breach of the New Zealand Bill of Rights Act if it was an unreasonable search and seizure, and then the next link in the chain, it will be an unreasonable search and seizure if it was unlawful for the police to have done what they did, or if it was a violation of Mr. Tamiafuna's reasonable expectation of privacy. So then we have to think, do we have a reasonable expectation of privacy on a public street? So remember, he's on a public street when the photo's taken. Does he have a reasonable expectation of privacy? Now, if I was to take a photo of all of you now, which I'm not going to do, but we're in what is sort of a public space, though it has some private aspects to it in the sense that perhaps the university, whoever, could say, oh, I'm sorry, you're not allowed to enter the room, and so on. Would that be a violation of your reasonable expectation of privacy? Now, the important difference might be, I'm not a police officer, so does it make a difference that Mr. Tamiafuna was on the public street because he was told by the police officer that he had to get out of the car? And does it make a difference that the police officer is the one who took the photo and then uploaded it to the police database? So at that first stage, if we're trying to decide, was the evidence improperly obtained, what we have is we have the Court of Appeal saying it was unlawful for the police officer to take and retain the photo. And the reason for that is because there is no sort of statutory power for the police officer to take and retain the photo in these circumstances. It's a different story if the police officer is investigating crime. Then they are allowed to do that, and we want them to be allowed to do that. But in this situation, the Court of Appeal has said it was unlawful. But what about this idea of reasonable expectation of privacy? Perhaps if I could just have a show of hands. Do you think that Mr. Tamiafuna should have been held to have a reasonable expectation of privacy in this circumstance? Now, there's no right or wrong answer, so show of hands if you think, yes, reasonable expectation of privacy. Okay, so probably less than half, but okay, so show of hands if you think he doesn't have a reasonable expectation of privacy. Okay, probably a majority says no reasonable expectation of privacy. Okay, so that is something that if you came to law school, we would have to debate and argue about, and I would then be saying, well, what are your reasons for that? Why do you say that? What do the other cases say about that? Now, let's assume that it is found that it was improperly obtained evidence. The next question for the court is, are they going to exclude the evidence? And they make that decision by a a balancing process where they take into account things like the nature of the evidence, the importance of the evidence to the case, the seriousness of the wrongdoing, whatever the wrongdoing might have been, and so on. And then they have to decide whether it's proportionate to exclude the evidence in relation to the wrongdoing. So here, we might think specifically about Mr. Tamiafuna's case, and we might say, well, perhaps the taking of the photo, if it is a breach of the New Zealand Bill of Rights Act, if it is improperly obtained evidence, perhaps it's not so serious. Now, I'm just saying perhaps. And then we might say, well, it's evidence that linked him to a serious crime, aggravated robbery, so we might say, well, exclusion would be disproportionate. We might say that. On the other hand, if we look at it more broadly, we might be concerned about the conduct of the police in other cases. So if we say it's okay for them to do it in this case, what does that mean in other cases? And you might have heard that back in around 2002, I think, there was a bit of an uproar because the police were doing this, routinely taking photos of young people and holding on to those photos, and in particular complaints from some Maori groups because the police were perhaps there was an allegation that it was a sort of racial profiling of the taking of photos of young people. And the Privacy Commissioner and the Independent Police Conduct Authority said that that was not okay for the police to do. So are there broader consequences to our answer here? Or are we just concerned about convicting Mr. Tamiafuna because we know that he was guilty? So again, no right or wrong answer. The courts have come out to different conclusions here, but if I could have a show of hands, do you think you would exclude the evidence in Mr. Tamiafuna's case? Yeah, we've got a few people who say they would exclude, and do you think you would admit the evidence in Mr. Tamiafuna's case? Okay, so more people saying they would admit the evidence. Now, as I said, if this was a class in law school, we would then be talking about, well, why have you said that? What aspects are you saying are more important? What things are you saying we should elevate over the others, and why? What is your justification for doing so? So that basically brings me to the end of my formal sort of presentation for you today, but there is plenty of time now for questions. So any questions that anybody has about what I've talked to you about today or about studying law in general, then please feel free, just put your hand up and I'll sort of take questions. But, yep.
What motivated the policeman to upload the photo in the first place?
Well, yeah, that's a good question. What motivated the policeman to upload the photo in the first place? Now, the police would say that although they weren't actively investigating a crime at the time, they pulled over the car and the police officer would say, I could see in the car that there were some women's handbags and nobody in the car was a woman. And so the police officer is thinking, oh, something's going on here and taking photos. But the important point is that he's not investigating any particular crime. So the police officer, if we're fair to the police officer, is thinking that this is an okay thing to do. This is a thing that New Zealand society would expect the police officers to do in the process of sort of looking after society, and would say that's why I uploaded the photo. And then they're lucky, if that's the right word, that then linked Mr. Tamiafuna to the earlier aggravated robbery. Other questions?
Yeah,
Yep.
so if this with the result from the Supreme Court, will this end up becoming a precedent situation that any other scenario where pictures of photo taken could be admitted?
So depending on what they decide, yes, it will have flow-on effects for police conduct and for the decision-making in other courts. So if the Supreme Court says that it's okay for the police officers to do this, then we can expect that they will do this more often. They will continue doing it if they haven't stopped. I don't know if they've stopped doing it at the moment, but they would continue. And then we would expect other courts having to decide the same issue. They would say, well, the Supreme Court said that that is okay, so we also say that that is okay, that is not improperly obtained evidence, and the argument would not succeed. Now, the other way around, if the Supreme Court says, no, this is not okay, then the police should immediately stop doing it if they are still doing it, and then perhaps the government would come in and provide legislation which provides rules and guidance for the police to say, yes, it is okay for you to do this, these are the circumstances in which you can do this. Now, if they say it's not okay, and they also provide guidance on the test of improperly obtained evidence, which is what Mr. Tamiafuna's lawyers are arguing for, because what Mr. Tamiafuna's lawyers have said in the Supreme Court is that Section 30 of the Evidence Act, which is about improperly obtained evidence, is not working the way it's supposed to. So they're saying the courts are letting in too much improperly obtained evidence. They've done some statistical analysis. Now, we might disagree with the basis of their statistical analysis, but they've done some statistical analysis, and they say in 80% of cases that go to the Court of Appeal, the evidence gets let in. And they say that that's not how Section 30 is intended to run. That is sort of putting more emphasis on this idea of convicting the guilty than it is on the idea of sort of what kind of justice system do we want to have? Do we want to have a justice system where the police have to follow the rules when they're requiring us to follow rules? Because if we don't follow the rules, we get convicted of crimes. And so Mr. Tamiafuna's lawyers are trying to argue that the Supreme Court should give more guidance on the test, which will, if they succeed in convincing the Supreme Court to do that, will then have flow-on effects for the lower courts and how they apply the test, and might then mean that more improperly obtained evidence is excluded than is currently the case. Yeah. Yep.
So was that case there, why did they pull the car over in the first place?
I think it's just a routine kind of stop. It was, I think, a semi-rural road early in the morning, and they just pulled the car over, and it. Yeah. So it just happened to be that the driver was unlicensed, and then they all had to get out of the car because the car was impounded.
So there was a fault there, but when they were pulling back in the 2002 profiling young people,
Yeah.
was that just pulling over anyone?
So the profiling of the young people, that was just a couple of years ago, so not back in the 90s, but that was just sort of random taking of photos. Not even related to cars, just random taking of photos of young people, and not that I'm aware of. Yeah, and that's also something that we do in law school. We talk about, is this situation similar to this situation, and therefore we should have the same outcome, or is it different, and why is it different? So, yep.
I don't know what the legal term is, but even if the evidence was excluded, the fact of the judge and jury knowing of it, wouldn't it likely influence them in other cases?
So, if it's excluded, even though perhaps the judge or the jury might have heard about it, they have to put it out of their minds, which we might say, well, that's not actually possible for somebody to do as a matter of reality. And so we might say, well, now there has to be a new trial with a new jury that doesn't know about this. Because juries don't give reasons in New Zealand. So when the jury decides guilty or not guilty, we have no idea why they have decided that. And so if you're a juror, you are not allowed to go and do your own research into a case. But sometimes jurors do that, and if we don't know about it, that might have influenced their decision. So that's a potential problem with juries where they don't give reasons. But yes?
So the video evidence of the aggravated robbery, could that not stand up on its own without the photo?
So it wasn't clear enough who the person was. So the thing about the video evidence is that Mr. Tamiafuna was wearing particular shoes that were sort of identifiable, but only once we know that it's him. And he was wearing, I think it's sort of grey gloves, and there was like a particular outfit he was wearing. And in the photo, he was wearing the same outfit. So had he been wearing something different, then we might not even be able to link the photo to the CCTV.
I feel like that evidence should be strong enough on its own to actually be, make a solid case,
but,
other than just a few clothes.
Yeah, so I see what you're saying. The problem is that the only reason they have any reason to suspect that that person wearing the clothing is Mr. Tamiafuna in order to charge him with the offence is because of the later photo that they can then be like, oh, that's Mr. Tamiafuna. And they did not know that and would not have known that without the photo. So there wouldn't have been anybody to charge because they wouldn't have been able to know which person to charge. Yeah.
Right, so if you, down the track, just because they didn't know beforehand, you still can't build a case.
I mean, down the track, if they had some other way that they had found out that was Mr. Tamiafuna, then that would be fine. They could then charge him. Yeah.
Like if someone phoned up and said, you've got to check this guy out and go and see, they might not be using that in the court case. But
yeah, so depending on the circumstances of the person phoning up, but assuming that that's all sort of ticking various boxes of legitimacy, then yes, that would be fine. Any other Or is there anything, so we've got 5 minutes left, is there anything anybody wants to talk about in relation to studying law? Any questions about studying law for anybody in the room? It's a really, really great subject because it's about problem solving and sort of a whole range of things. What do we expect in society? It's about history, but yeah. So why do you have to do a conjoint? The reason why you have to start out doing a conjoint is because you have to get into second year law in order to carry on in the law degree. So everybody is allowed to study first year law, and they take a conjoint at the same time so that they're also exposing themselves to some other area that they might be interested in. But in case they decide that they don't like law, they have another degree that they can do, or perhaps they don't get into second year law because their grades don't quite get them into second year law. They have another degree that they can do. And it is common that, well, not common, but some students who don't quite get into second year law, they then repeat some of the first year law papers in order to get better grades to then have a second chance, but in the meantime, they're studying their second degree. Now, it doesn't mean that you have to keep studying a conjoint. It might be that you decide, actually, law is really the thing that I want to do, and I'm just going to do a law degree. That's what I did, actually. So I started out doing, I think it was law and like psychology or something like that. And I decided I just really love law so much that I'm just going to do a law degree. So the reason why you do the conjoint at the start is so you have options. Yeah. Yep.
How many papers, if you did a conjoint, how much of that time do you have to give? Is it like doing full time?
So you do, I think if you do a conjoint law and another degree, on average it takes around 5 years to complete. So it probably takes maybe a year longer or so than if you just did a law degree or you just did a whatever the other degree is. But you still do only, say, 8 papers a year. So it's not that you have to suddenly do all the papers that you would need for that one and all the papers for that one at the same time. So first year law, the requirement is 3 papers, Law 121, Law 131 and Law 141. And then your other 5 papers, if you took 8 papers, which I think is like a full-time load, could be from your other degree. And then in your subsequent years, you might do you might do 2 law papers in your second year and 6 of your other degree and so on. So you kind of mix it how suits you, really. Yeah. Thanks. Yep. I don't actually know what he looked like, but perhaps. Yeah. Thanks. Okay, any other questions? Yep.
Personal question.
Yep.
Why did you pursue academia rather than a career?
Good question. So I still really enjoy both academia and practice. So I'm just doing academia at the moment, though every now and then I do a little bit of like consulting stuff. My sort of dream role would be doing both. But the difference is, so I was working in litigation, which is the stuff where we argue in court, which I found really interesting because I like the sort of problem-solving aspect of trying to find an answer. But that's very dependent on what your client needs and who your clients are. So you don't get to just go and sort of research whatever you want because you have a client and they have a problem and you have to solve their problem, which can be very satisfying. But then there is also, for me, I'm just interested in sort of research and so on, and so academia means that I can basically, go and research things that interest me, and I don't have to have a client who needs that problem solved. And also, a client is only going to pay so much for so much work. They want the answer, and then you get the answer, but you can't keep looking into something that you find interesting because they're not going to pay for that. So yeah, that's.
And would your colleagues,
Yeah.
most of your peers at university are similar?
So we have a range. So we have some people who haven't practiced law in the past. Then there are people like me who have worked in law, practiced law. There are people who do some legal practice while they're teaching as well. So it's a real mix. Yeah. So I mean, that's good. That's a good thing because we have some people who are able to speak more about their personal experience as a lawyer and so on, and some people who are looking much more detailed about sort of theoretical kind of things that more sort of academics who haven't practiced might be more interested in theoretical stuff compared to. I mean, so for me, I'm really interested in evidence law, and that's probably because I've practiced law, and so I've used those ideas. Let's just have one more question, and then we'll have to. Yeah.
What made you get into law?
What made me get into law? So you mean like what got me interested in law? So when I took my first year papers, I didn't know what I wanted to study, and so I took law as one of the things just to see, do I like this? And I just really, really liked it. And so then I kept doing it. So in my first year, I was taking some law stuff. I was taking history. I was taking psychology. I was taking like accounting, which turned out to be, for me, really boring. But, you know, I took it to see, do I like it? And I just really liked law. And then that was it for me, basically. Yeah. Great. Okay. Well, thank you very much, everybody, for coming. And hopefully I'll see you next year in Law 141.